A sitting federal judge opened a sealed folder, reviewed the official court record, and then looked directly at the director of the FBI and said words that have never been spoken in that context before. What you stated under oath does not match what these documents show. Not an opposition senator, not a hostile journalist, a federal judge, on the record, in open court, and the moment those words landed, one word began circulating through congressional hallways that no one had dared say out loud, until now: removal. But the headline version of this story is missing the most important part. Because this didn't begin in that courtroom, it began months earlier, with a promise, a specific sworn public promise that is now at the center of everything. When Kash Patel sat before the Senate Confirmation Committee, he wasn't vague, he didn't leave room for interpretation. He told Senator Coons directly, there will be no politicization, there will be no retributive actions. Then Senator Blumenthal pressed harder. And Patel didn't flinch. Every single FBI employee, he guaranteed, would be safe from political targeting. On the record, before the country. Unequivocal. The votes came in. Patel took the seat. Then the terminations began. Not one, not two. At least 10 senior-level FBI personnel, removed inside a compressed, deliberate timeline. These weren't agents flagged for misconduct or poor performance. These were experienced investigators who had built careers around one of the most politically radioactive cases in recent memory, the classified records investigation. Gone, fast, quietly. And the timing didn't require a conspiracy theorist to notice, it required a calendar. But Patel had his language ready. He stood before Congress and delivered the institutional cover with practiced ease. Anyone terminated had failed to meet standards, failed their constitutional oath, failed the mission. Bureaucratic framing, airtight on the surface, designed to absorb scrutiny without cracking. Then the judge pulled out the actual documents. Here is the precise moment this story stops being political and becomes something a federal prosecutor studies. Patel entered that courtroom and testified about specific legal restrictions, formal court orders, he claimed, that made releasing certain files legally impossible. His hands were tied. The law required non-disclosure. He laid it out with confidence. The judge then examined the court's official record. The restrictions Patel described under oath were not there, not redacted in a manner that blocked release, not classified under categories that justified withholding. The specific legal architecture Patel had constructed in sworn testimony, it wasn't in the documentation. The judge held both in hand. The gap between Patel's words and the verified court record was not a matter of interpretation, it was a documented, verifiable contradiction. 12 seconds of silence followed. Reporters in that room stopped typing. The judge's response carried the weight of the entire federal legal system: comply with the document release by a hard deadline, or face criminal contempt charges and a formal referral for perjury prosecution. 5 years. That is the federal sentence for perjury, not a political outcome, a prison sentence. Now hanging over the man who runs the FBI. But there was a dimension to this story that hadn't surfaced yet, and when it did, the entire architecture became visible. Senator Dick Durbin walked into the hearing room with sources, not speculation, not political accusations, whistleblowers, people inside the system, people who had seen the actual communications. Their account, delivered to congressional investigators under protected disclosure. The agent removals weren't Patel's initiative, they were being directed. The name attached to those directions was Stephen Miller, one of the most strategically positioned figures in the administration. According to the whistleblowers, the communications were specific: which agents, what timeline, what the strategic objective was. When congressional investigators put that directly to Patel, his response was immediate and flat. No knowledge of any such communications, not involved, didn't know. The whistleblowers had documentation, so now the picture has both walls. The FBI director testifies he acted alone. Sources with physical documentation say someone above him was running the operation, and the investigators who assembled the underlying evidence, the ones whose work created the exposure in the first place, have already been removed from the building. This is where the two storylines reveal themselves as one. The documents Patel tried to seal in that courtroom, tied directly to the same investigation the terminated agents had spent years building. The legal barriers he constructed under oath, positioned precisely to protect the same files those agents had been assembling into formal cases. Lay the events in chronological order, and the sequence speaks for itself. Neutralize the investigators, then construct a legal justification for why the record cannot be examined. Each move covers the previous one. That's not a stumble, that's architecture. And Patel didn't stumble into these files as a newcomer. He had been involved in the political orbit surrounding these exact investigations for years before he took the director's chair. He knew which investigators had built what. He knew which documents carried the heaviest exposure. What the federal judge revealed in that courtroom was not ignorance, it was precision used incorrectly. Inside FBI field offices, the reaction was something career agents describe as a kind of vertigo. These are investigators who took an oath and spent decades building cases based on evidence, not on who the subject was or which political weather was blowing that week. Watching their director get documented in a contradiction by a federal judge wasn't abstract. One senior agent told congressional investigators that the environment had shifted from law enforcement protocol to something that felt like a loyalty audit. Cases were being filtered through a political frame before the legal analysis even began. That's not the FBI that swears people in, that's something else. And here is where the consequences stop being theoretical. The judge issued a formal compliance order. Deadline attached. 2 instruments in play: criminal contempt and perjury prosecution referral. If Patel doesn't comply, or if the prosecutorial threshold for acting on documented false testimony is met, the sitting director of the FBI could be criminally charged. His law license, his federal standing, his career, all of it now inside the blast radius of a federal judge's documented findings. The political movement around this has already started changing shape in ways that don't reverse easily. Republican senators who cast confirmation votes have gone conspicuously silent. Democratic leadership has moved past oversight rhetoric and into formal discussions about accountability architecture. Impeachment is no longer being treated as a political threat. It's being analyzed as a procedural obligation. When a federal judge documents potential perjury by an administration official, what does Congress have a constitutional duty to do? That question is being asked in committee rooms now, not just on cable panels. The numbers confirmed the shift was real. A Quinnipiac poll released May 21st showed Republican disapproval of Patel had nearly doubled in 8 months, from 10% to 18%. His own base was beginning to ask questions he had no clean answer for, and the internal damage runs deeper than any poll. 3 FBI field office directors, Chicago, Miami, and Denver, submitted formal written objections to FBI headquarters within the same 30-day window. Patel's courtroom contradiction became public record. Not leaks, not anonymous complaints, official, documented, signed objections. That kind of institutional resistance hasn't happened inside the Bureau since the Church Committee hearings of 1975. One hearing moment captured the full weight of what Patel is now facing. A senator held up documentation mid-session, a $7,000 bar tab charged against the taxpayer account, tied to a Washington, D.C. lobby during the El Salvador trip. The authorization chain, who approved it, who was covered. Patel denied everything with the same controlled confidence he had used throughout every prior appearance. The senator leaned into the microphone and said he wasn't the one making the allegation, the documents were. The cameras caught Patel's hand close tighter around the edge of the table. His jaw held, but something behind his eyes shifted, the specific expression of someone who built their position on the assumption that no one would look carefully enough, now watching someone look carefully enough. That expression doesn't perform, it surfaces. That same month, The Atlantic published a detailed account of conduct concerns that had circulated across multiple levels of government. Patel's answer was a $250 million defamation lawsuit. The reporting didn't retract. Here is the thing about a federal judge's documented findings that press strategy cannot reach. They don't respond to news cycles. They don't soften under political loyalty. They don't expire when the administration changes the subject. What a judge puts into the official court record lives in that record, and what prosecutors do with that record depends on evidence and timelines, not on whether the subject has powerful allies or controls a press operation. You can absorb political attacks. You can run out oversight windows. You can deliver institutional language until a hearing closes and the cameras turn off. What you cannot do is walk into a federal courtroom, make specific sworn claims about official legal documents, and survive the moment when the judge holds those claims next to the actual documents and finds they don't correspond. That is a category of exposure that has no press strategy. It has prosecutors and grand juries and deadlines. The question Washington is sitting with right now is not whether Patel contradicted the official court record under oath. A federal judge has answered that. The question is what happens when that documented answer meets political protection, institutional resistance, and an administration that has consistently moved to shield its own people from accountability consequences. And beneath that question, quieter, more corrosive, more permanent, is what career investigators across the country are asking in their own offices. If the director of the FBI can place false testimony in front of a federal judge, remove the agents whose work exposed the contradiction, and remain in his position while contempt warnings accumulate, what does the FBI's authority actually rest on right now? What does an oath mean inside an institution where the person at the top of the chain may have violated his own? Federal judges operate on deadlines, grand juries operate on evidence, and documents, once they enter the official record, do not disappear because the subject wants them to. Now here is the question I want you to answer, and I want you to be specific. A federal judge has documented a direct contradiction between Kash Patel's sworn testimony and the official court record. Whistleblowers with documentation allege he received outside direction on which investigators to terminate. His own poll numbers among his own base have nearly doubled in disapproval in 8 months. Given all of that, do you believe a federal prosecutor should open a criminal case? And if not, what exactly would it take? Drop your answer below. Say it plainly. Because the people who are supposed to be asking that question inside the system are not saying much. And the comment section is the one place right now where the actual answer is getting spoken out loud. This story is not finished, not even close, and the next development, when it comes, will not come from a press release or a political statement. It will come from a federal docket. Watch for it, because here is what every person watching this needs to understand about where we actually are. The infrastructure of accountability in this country, federal judges, grand juries, inspector generals, sworn testimony, was built specifically for moments like this one. Not for normal bureaucratic disagreements, not for political disputes dressed in legal clothing, for moments where the evidence in the official record contradicts what a powerful official said under oath, in court, on the record. That infrastructure is being tested right now, against significant pressure, against institutional loyalty.